This is an appeal from the trial court on an award of attorney's fees under the GTLA section 292113. In this case, it was about a young pregnant mother who was concerned about being able to support her child, and so she looked to adoption. Several defendants were named in the action, including the California adoptive parents, the California attorney, the local adoption agency, and the hospital social worker. The mother was told she would be provided a Tennessee attorney, which never happened. She was scheduled for a C-section in advance of her birth, and she was induced into signing California documents to surrender her child, all under the stress of childbirth and drugs. Her child was handed over by the hospital employee, defendant Reed. The mother was able to retrieve her child, but not without agreeing to waive liability under duress. Mother brought the case for negligence, civil kidnapping, and conspiracy to commit a fraud. The court granted dismissal, which was appealed, and a court of appeals upheld the dismissal. The plaintiff filed a timely Rule 11 application pointing out that the Court of Appeals opinion was an incorrect application of the law. The Supreme Court denied the Rule 11, but marked the opinion not for citation, basically ending the mother's ability to litigate her objections to the Court of Appeals opinion. Attorney's fees were then sought in the trial court. Mother appeals the award of fees to Kelly Reed, who is the employee of the hospital Cookeville Regional Medical Center, which I will refer to as a CRMC. The appellant basically raised four arguments. One of them was an argument as to the strict compliance of 292113. And the mother also raised constitutional challenges, both facially and as applied, and a violation of public policy. The first argument is the mother argued that there would have to be a verbatim application of 292113. To award fees under that section, there must be certain criteria that is met. They must be an employee, which we kind of argued in our brief that perhaps she would not be considered an employee, but I am going to submit that I will withdraw that part of the argument. However, the other two elements are that is in her individual capacity, and that the claim arises from the actions or omissions of the employee acting in an official capacity or under color of law. And we submit that the claims against Kelly Reed were neither of those. Official capacity acts are generally supervisory acts or policy-making acts that affect the rights of the individual. Color of law is under the authority of law, such as civil rights violations. This is a negligence action against the employee, and this was confirmed by the Court of Appeals. Now, the Court of Appeals found that Ms. Reed did provide health-related services and said that she did not get the proper pre-suit notice. The Court of Appeals then dismissed, or the trial court, and as affirmed by the Court of Appeals, dismissed the case with prejudice. Mother's Supreme Court application argued that the court should have found substantial compliance and dismissed it without prejudice. So therefore, under the strict application of 292113, we believe the trial court should be dismissed on the award of attorney's fees to defendant Kelly Reed. Now, the mother plaintiff also made constitutional arguments, arguing that access to the courts under Tennessee Article 1, Section 17, and the United States Constitution, Due Process Clause of the 14th Amendment, the First Amendment, and the Privileges and Immunities Act of Article 4 would be violated for application of these harsh attorney's fees statutes. On page 26, she argues strict scrutiny, and she argues rational basis under page 28 for facial challenges. However, I am going to focus in my short time on the as applied challenge, which starts on page 29. And again, as I previously stated, Mother's Rule 11 application to the Supreme Court was denied, but her entire Court of Appeals opinion was marked not for citation. Mother basically brought a cause of action before the court for consideration of the unlawful transaction of a child, or civil kidnapping. This was actually recognized by the Restatement of Torts in 702. However, the Court of Appeals found that the child relationship cannot be bargained away. However, this is exactly what is prohibited under the adoption statutes under 36-1-109. Mother claimed it was a conspiracy for a civil kidnapping for which she should be compensated based upon the actions of the defendants. So she was also denied access to the courts in the Court of Appeals misapplication of 2926-121 and the misapplication of the Share Doctrine. So again, separately, the 2926-121 would have provided for a dismissal without prejudice to the mother plaintiff, and she would have been able to refile her claims. The other dismissal was to CRMC on what would be termed as the Share Doctrine. And the Share Doctrine says that if the agent is dismissed, you can no longer pursue a claim against the employer. So, but under Absher, it was very clear that those were claims that were on the merits, such as res judicata and the statute of repose. In this case, it was a pre-suit notice, which should have been dismissed without prejudice. So therefore, this court should find, first of all, that there was the court did not strictly apply the elements of 2920-113 in that it was not a claim of her acting in her official capacity or under color of law. And secondarily, if you need to go there, because as I know, constitutional challenges are always secondary to any other basis for reversal, but secondarily would be the as applied challenge, as I believe the appellant's strongest argument is that she was basically cut off from a full adjudication of her claims, and her case was basically erased from history with being marked not for citation, and yet being denied the supervisory powers of the Supreme Court.
Ms. Regularly, on what basis do you make the statement that your client's case is erased from history based upon the designation as not for citation?
Well, Your Honor, I believe that under, and I have that marked in here, under Supreme Court Rule 4, Section E, I mean, it's law that cannot be cited. I mean, it is the law in her case, and her case has been dismissed. But those challenges that she brought, and especially the issues of the civil kidnapping, which I talk about in the brief and in her Court of Appeals application and in the lower courts, about how the courts really should consider this cause of action.
Isn't that opinion still a matter of public record?
It's not. Yes, it is public record, but it's not
Therefore,
applicable.
It's not erased from history.
Well, her ability to litigate and use the supervisory powers of the court to look at that cause of action has been stopped.
No, what the Supreme Court did is it affirmed the Court of Appeals decision.
Yes, it did.
That remains of public record.
Yes, it does. Yes, it does. But under Rule 4, not to be cited as authority. So,
in a case involving parties who are not parties to this action.
I'm sorry, you cut off there a little bit, Judge.
And it is not to be cited except by parties to this action in this dispute.
Correct. All right, and I will pass the argument.
Oh, I'm sorry. Thank you very much. We'll now hear from the appellee.
Good afternoon. I'm Cynthia Wilson of the Putnam County, Tennessee Bar. I represent the appellees Cookeville Regional Medical Center Authority, which I will now refer to as the hospital, and Ms. Kelly Reed, who is the hospital's employed licensed clinical social worker. Briefly, I'll touch upon the facts because they're relevant to the rest of my argument. Ms. Taylor arranged for the adoption of her daughter immediately after birth. While in the hospital for delivery of the baby, Ms. Reed, in her capacity as a licensed clinical social worker, assisted Ms. Taylor in the completion of hospital forms affecting the surrender of Ms. Taylor's baby for adoption, which was all prearranged. After discharge from the hospital and surrender of her baby, Ms. Taylor changed her mind about the adoption and thereafter obtained physical custody of her baby. Relevant to the surrender process of the baby to the then adopting parents, Ms. Taylor sued the hospital, Ms. Reed, and others for healthcare liability and intentional torts. The hospital and Ms. Reed filed joint motions to dismiss, which was granted on appeal, affirmed by this court. Was granted and on appeal was affirmed by this court. The Tennessee Supreme Court affirmed the Court of Appeals opinion, but discretionarily denied Ms. Taylor's application for permission to appeal and designated this court's written opinion not for publication pursuant to Rule 4 of Tennessee Supreme Court. Thereafter, Ms. Reed and the hospital, as payer of Ms. Reed's attorney fees, filed in the trial court a motion for attorney fees pursuant to Tennessee Code annotated 2920-113. I'll call that the fee statute. This petition was granted. Ms. Reed appeals the award of the attorney fees to Ms. Reed and the hospital as payer of those fees. She raises two issues. I'll briefly address the same. Did the trial court err in awarding attorney fees under the fee statute for failure to strictly comply with the statute? No. For there to be an award of fees to Ms. Reed, the fee statute requires that Ms. Reed be an employee of a state or governmental entity, which is addressed at length in the brief, but not in the oral argument here today, and that she is sued in her individual capacity. Ms. Taylor's claim against Ms. Reed must arise from acts or omissions of Ms. Reed acting in her official capacity, meaning as an employed social worker for the hospital, or under color of law, acting as a social worker for the hospital. And Ms. Reed must successfully defend the claim, which she did, and incur attorney fees while doing so, which she did. Regarding the issue of a governmental entity, which I indicated is addressed at length in the brief, I'm going to address that now. Tennessee Code annotated 2920-102-3A defines a Tennessee governmental entity to include one or more of the named local governmental entities or by an act of the General Assembly. The hospital was originally established by charter of the city of Cookeville pursuant to Chapter 223 of the Public Acts of 1961. Subsequently, the hospital was established as a hospital authority pursuant to the Private Act Hospital Authority Act of 1996. Also, in 2014, the Tennessee Supreme Court held that in the case of City of Cookeville versus Humphrey, that the hospital is a local governmental entity and hospital authority. Therefore, the hospital is a governmental entity. Ms. Taylor also claims that Ms. Reed acting in her official capacity for the hospital. Paragraph 12 of the complaint states that in her work and communications with and to Ms. Taylor, Ms. Reed was acting in her capacity as a hospital employed social worker. By virtue of the facts in paragraph 12 of the complaint, Ms. Taylor alleges that Ms. Reed was acting in her official capacity as the hospital's employed licensed clinical social worker and is therefore, because it's a governmental entity, under color of law. As well, in subsection B1 of the fee statute says, for purposes of this section, the employee shall be a prevailing party if the employee successfully defends the claim alleging individual liability. Ms. Taylor alleged in the complaint that Ms. Reed is guilty of conspiracy to commit fraud, tortious civil kidnapping, and conversion, all of these being intentional torts for which a governmental entity cannot be held liable. She also requested in the prayer in the addendum the sum of $50 million to be paid by the defendants based on joint and several liability this being individual liability for Ms. Reed. As such, Ms. Reed was sued in her individual capacity. In subsection D of the fee statute, it provides that attorney fees and costs shall be paid to the governmental entity if it retained and agreed to pay counsel to represent the employee sued in her individual capacity. The uncontested declaration of Luke Hill, who is the chief legal counsel for the hospital, verifies that the hospital retained me as counsel to represent Ms. Reed, and the hospital further agreed to pay the fees incurred by Ms. Reed in defending this action. All the provisions of the fee statute have been met to support the attorney fee award by the trial court. Additionally, Ms. Taylor has waived any arguments that were made in the appeal but not presented to the trial court. In her response to the hospital and Ms. Reed's motion for attorney fees and costs, Ms. Taylor did not argue that the hospital is not a governmental entity. She did not argue that Ms. Reed was not sued in her individual capacity. She did not argue that Ms. Reed was not acting in an official capacity, and she did not argue that Ms. Reed was not acting under color of law. Thus, these issues are waived. The second issue argued by Ms. Taylor is whether the fee statute is unconstitutional, and the answer is no, it is constitutional. Ms. Taylor argues that the fee statute violates her constitutional right to access to court, but literally Ms. Taylor has not been denied access to court or shut out of court. She has litigated her underlying claims from the trial court to the Court of Appeals and attempted to appeal to the Tennessee Supreme Court, but was ultimately discretionarily denied permission to do so. Accordingly, she has no injury and therefore no standing to challenge the constitutionality of the statute. But assuming Ms. Taylor has standing, I will address briefly her other arguments. She advances a loose argument that the fee statute violates the separation of powers clause and is therefore unconstitutional. This fee statute is remedial in nature. It has long been the law that the General Assembly may alter, enlarge, modify, or confer a remedy available to persons seeking judicial relief. Thus, Ms. Taylor's separation of powers argument fails. Ms. Taylor argues that the fee statute violates the equal protection clauses of the Tennessee and federal Constitution because it burdens her fundamental right to access to the court. But as noted just previously, she has not been denied access to court. And as well, Ms. Taylor is not a member of a suspect class or a quasi-suspect class, and the fee statute is facially neutral. Therefore, this court should not use strict scrutiny as a basis to review to determine the constitutionality of this statute. If the fee statute does not involve a suspect or quasi-suspect class or burden a fundamental right, then it will be reviewed to determine whether or not it is rationally related to a legitimate government interest. And unsurprisingly, it does. The state of Tennessee has a legitimate interest in the protection of the public employees from the expense of defending a claim. And as opposed to other laws providing protections for employees from frivolous and vexatious litigation, which might be applicable here, this fee statute affords government employees additional protection, which is constitutionally permissible. All of Ms. Taylor's arguments have failed. The fee statute is constitutional, and the fee award should be upheld. Additionally, my clients request the court to remand this case to the trial court to assess and award attorney fees and costs incurred in defense of this appeal, and such award be made against the appellant and her counsel. Thank you.
All right. Thank you, Ms. Wilson. And we have a second appellee we'll hear from.
Thank you. Good afternoon. Mary Elizabeth McCullis on behalf of the state of Tennessee. The state's sole role in this appeal is to defend the constitutionality of the fee shifting statute found at Tennessee Code Annotated 2920-113 against plaintiff's challenge. And that challenge, the only challenge that plaintiff has raised on appeal, is that the statute denies her access to courts. This fee shifting statute does not violate a fundamental right. It has a rational basis. The statute's application in the context of plaintiff's case was not unconstitutional, and the statute does not violate the American rule or Tennessee public policy. Thus, the state respectfully requests that this court affirm the trial court's judgment that the statute is constitutional because it does not prevent access to courts. Plaintiff asked this court to find that the statute violates the fundamental right of access to courts and should be subjected to strict scrutiny or alternatively a rational basis test. Right of access to courts is not a fundamental right. The Tennessee Supreme Court in Hughes versus Tennessee Board of Probation and Parole has found that all of its citizens have a constitutional right to access the state's courts, but this right is not a fundamental right, such as due process, equal protection, or freedom of speech. The U.S. Supreme Court in Christopher versus Harbury has also found that while there is a constitutional right to access courts, that right is not a guaranteed right under all circumstances, meaning a plaintiff claiming denial of access to courts must have a claim for injuries sustained because that plaintiff could not access the courts. And plaintiff here has no such claim because she filed her lawsuit and pursued her litigation below. Because access to courts is not a fundamental right, the appropriate review to apply to the statute is whether the statute has a rational basis. And the answer is the statute does have a rational basis, and that basis is reasonable. This rational and reasonable basis is that the state has a legitimate interest in protecting governmental employees who have been sued in their individual capacity. Public employees are, by the nature of their employment, thrust into a role as the front-facing representative of a governmental entity, possibly making them the focus of dissatisfaction and thus subject to suit. This statute financially protects individual public employees from meritless suits. Simply put, a public employee who is performing their duties and has prevailed in a lawsuit brought against them should not have to bear the expense of having to defend themselves against the claims in that lawsuit. Plaintiff also attacks the rational basis of the statute from another angle. She claims that other rules and statutes protect litigants from frivolous or vexatious litigation, and thus there's no rational basis for the additional provisions of this statute. But that rule and the statute cited by plaintiff apply to different circumstances that do not exist in this case.
General, does there have to be affirmative proof that the employee himself or herself is actually incurring the legal expense as distinguished from the employer incurring the legal expense of defending the action?
No, the statute allows for the payment of expenses depending on who has actually defended the employee. So it could be the employee incurring the expense, the governmental entity incurring this expense, or as in this case, a private law firm putting forth the expenses that then need to be reimbursed. So in conclusion, the state respectfully requests that should the court find it necessary to address the constitutionality of this statute, that the court affirm the trial court's judgment ruling that the statute is constitutional.
Thank you, General McCullis. Ms. Reguly, you have 5 minutes for rebuttal.
Sorry, I was muted. Just a couple comments I would like to make as to the rational basis. I know the state put in their brief that the state argued that they have a legitimate interest in discouraging non-meritorious claims. And that's where I argued that clearly state law and civil procedure do provide for remedies for vexatious and frivolous litigation under Rule 11 and under TCA 27-122. And that non-meritorious claims and frivolous claims are not the same. And even the law states that a lawyer has a duty to a client to bring a substantial justiciable question, even though it may lack merit in the end. And so in this case, there clearly was wrongful conduct. I would dispute the articulation of the facts as stated by Ms. Wilson. And under this standard, you have to take our facts as stated as true, and that this was not some agreement well in advance for adoption, but that mother was kind of tricked into the situation, honestly. So clearly there is an issue here where there was some legitimate concern for wrongdoing. And then I just finally want to close with the other argument that I put in my brief was the public policy consideration. American jurisprudence has long adopted as public policy the American rule of attorney's fees in considering that litigation in and of itself is inherently uncertain, and a party should not be penalized for bringing or defending a lawsuit. It unjustly discourages instituting actions to vindicate rights where a penalty is attached if their claim is ultimately insufficient but not found to be frivolous. So I think that I think the application of this statute, and then finally in my brief, I do talk about the comparison to 2012-119C, which is the assessment of attorney's fees under Rule 12, and would point out that specifically under that statute, there's sort of two protective stopgaps. One of them is it states specifically that if a plaintiff brings a claim that, let me say the language if I have it, a good faith litigation where there's a non-frivolous claim for the express purpose of extending, modifying, or reversing existing precedent or law, which is not provided under the 2113. And the other thing is there is a cap. There's a cap on the fees, a limit of $10,000 to be distributed among the defendants under the 2012-119C, which I think provides some protection against the perhaps non-meritorious litigation, but is not found to be frivolous. So, and you can see from this situation where Ms. Wilson is asking for $42,000 and now additional fees for her appeal, that it way extends what the legislators had considered as a reasonable penalty, so to speak, for a claim that is lost on a Rule 12 motion or situation of failure to state a claim. And that would be all.
Ms. Mccullis, let me ask you a question, please. You stated in your argument earlier that you're no longer maintaining that Ms. Reed was not an employee. Is that correct? You're not arguing that she was not an employee?
That is correct.
And are you arguing that the hospital was not a government entity?
No, I'm not arguing that. But I do believe in my argument. I think the official capacity claims are different than acting as an employee. So I think when you look up, and I put in my brief the description of what official capacity claims are, where you are basically acting as in place of the government entity and under the color of law. So I think that those two fail. And I did object to the application of the statute, even if that specific argument was not made. Thank you.
All right. Anything further, Ms. Reguli? All right.
That's all. Thank you, sir.
On behalf of the panel, we want to thank Ms. Reguli, Ms. Wilson, and General McCullis for your arguments and the briefs, and all of which we will take under advisement. Ms. Dempsey?
This honorable court is in recess until 2 p.m.
Thank you, and counsel, you are free to exit the Zoom.